For most of history, the law looked like some sort of Gnostic wisdom. There was this hidden knowledge, like a priest class that had been initiated into it. They knew which books to open. The lawyers, these Gnostic priests knew which words to say. They knew the rituals. I mean, even like where to stand, when to sit, when to object, when to stop talking, and what magic words would cause a judge to pause and then respond. And even the architecture, like the courthouse itself, is like you're walking into a temple. There's this metaphorical curtain that separates the initiated from the priest class. There's like literally a bar separating the public from the lawyers. And there's this altar-like bench elevated above everyone else. And of course, there's this mysterious robed man or woman prepared to judge you and the case. There are robes, there's rituals, and there's these words that mean something completely different inside the courtroom than what they mean outside of it. And for a long time, if you weren't initiated into the priest class or you didn't give the proper sacrifice at the altar of the billable hour, the books might as well have been hidden from you. But they're not anymore. The statutes are online. The cases are online. The rules are online. And you can read the same sources that lawyers read, and you can ask questions now using AI to help translate this vocabulary that used to take semesters of law school and years of practice and lots of reading to understand. So what I'm saying is the old monopoly is breaking down. Legal information is becoming nearly free. But that doesn't mean that judgment's free. It doesn't mean that experience is free. And it doesn't mean that knowing what matters or what doesn't matter, like who to believe, what to distrust, it doesn't mean that's going to become easy. So really there's this new dividing line. It's no longer what do I need to know? Like who has access to the secret books? Which lawyer is going to be able to tell me what matters? Who knows how to read them and test them and use them intelligently? That's the new question. It's about judgment. And that's what I want to start teaching you. My name is Mike Arnold, and I'm coming at you from about 100 feet away from Oregon's beautiful McKenzie River. And this is the St. Maximilian Kolbe Justice Clinic. This is lesson 1 of what I'm trying to build into an open source law school. How to build and present your case. Or as you might want to have it be called, how to win a case. But really, I think it's best framed as how not to lose your case to procedural illiteracy. Okay, so what I'm promising you, if you give me the next hour or so, I hopefully will give you a roadmap of a case. You're going to learn how to identify what the court is actually deciding, what has to be proven, which facts matter, and how to make these facts become usable evidence. For instance, who needs to testify? How do you test credibility if you have a liar on the other side? And what questions should you be asking next? You're not going to become a lawyer or even a great litigant in the next hour. But trust me, it took law school a long time to teach people that. I got gray hair now, made lots of mistakes, had a lot of suffering to get this far, witnessed a lot of suffering too, and have made mistakes, lots of mistakes. And you don't want to make the mistakes at the critical moment while you're in court because you hadn't done the research. But you should be able to take almost any contested legal problem after listening to this and start breaking it down intelligently. So instead of staring at like a pile of papers or having this swarm of chaotic facts in your mind, you should be able to at least go and cogently ask an attorney a question or prepare an AI question, or most importantly, get yourself ready for trial. Because this information is not hidden anymore. The hard part is judgment. And I can't give you 25 years of judgment in 1 hour, just the roadmap. Because over time, I've done what passes as high-profile criminal defense and complex litigation in our little state of Oregon, stuff that nobody would care about in like New York or LA. I've handled murder cases, serious criminal cases, civil litigation, tried jury trials in state court, federal court, municipal court. I've talked to juries all over the state of Oregon, and I've learned a lot along the way by making mistakes. I've had business disputes that I've taken to juries. I've had personal injury cases I've tried to juries. And I've had countless number of restraining orders, stalking orders, custody cases that I've tried to judges. But one thing I've learned is these are all kinds of situations where human beings were behaving very differently once the stakes got high. I've even had a couple of episodes on CBS 48 Hours and had like cases of local and some minor national attention. And I'm still preparing cases right now. I run a law firm. So I'm not a retired professor telling you what trial practice used to look like, and I'm not even really qualified to teach you anything. But I'm sitting here on a Saturday morning, and I'm recording this for you so that in the future, when I host these live clinic sessions, people will come in a little more prepared. But I want to be very careful and let you know this, that I'm a jack of all trades and master of very few, if any. I don't know everything, and nobody does. What I do have is a lot of accumulated pattern recognition from trials and hearings and witnesses and winning and losing and years of watching what actually happens in the courtroom like collide with like theory and real people in real time. And that's what I'm trying to give you here. Not AI slop about how you're going to win a case, but a framework that maybe you can find useful and start thinking about how to win a case. So no promise here, except I'm going to stick with you for as long as it takes to help get you a little more information. If it's not here, it'll be in our Facebook group or in the live clinic every Saturday. So let's talk a little bit about the rules before we get started here, because the rules are important, because you have the ability to comment down below, and I encourage you to do that. You have the ability to participate in our online forums or come into our clinic. But the webinar is for educational use only. Nothing at all that you hear today is legal advice. Nothing creates an attorney-client relationship. There's no confidentiality if you put a comment down. I don't know your record, your jurisdiction, and your case facts. So I'm not going to be able, in our live clinic, be able to give you legal advice. This is just educational. So you get what you pay for. And so if you follow some sort of idea that I had that I told you isn't legal advice, you're not going to be able to sue me later. And your best bet is always to hire an attorney, right? But I know people can't afford lawyers. I know that there's waiting lists for lawyers, and hopefully this will get you started in the right direction. And I want to see these questions. Like I want you to subscribe. I want you to make comments below. But before I teach you how the machinery works, I should probably tell you, why I think I have anything worth teaching at all. So I run a law office, and the way we do things, the craft, the method, which is like an operating system on how we run a case. We call that techne law, the techne way, because techne in Greek means craft. And the way lawyers do business, it's not just a list of tasks to be done. We're not a bunch of task monkeys running around. We have a certain craft that we do that requires us to accomplish tasks. And but there's like this machinery of what lawyers do that take chaos and turn that into some sort of order that is what we call the human story. You could have two very competing narratives, different legal elements, which are things that need to be proven, witnesses, motives, prior statements, and all the chaos flying around. And what we have to do as storytellers, you as a litigant or a client to another lawyer, we have to create order. We have to organize these words and ideas and symbols into some sort of script that a fact finder writes into their own mind about what happened. What do I believe? Who do I believe? What evidence matters? Like, what's the law that's required here, which is like an undercurrent of the script. Is this a science fiction and the laws of gravity aren't there? Is it here on Earth where the laws of gravity apply? What's the law of the story? And what am I supposed to do about it? And when I say script, what I don't mean is like scripting testimony or manufacturing facts. This like our series is for defeating liars, and when there's a legitimate debate over what happened with people trying their best to tell the truth, those are great cases to be in. But I know a lot of you are fighting liars in court. I mean, my Twitter handle is Mike Arnold Law, Liar Hunter. right? Because that's what we do. We search and seek the truth while other people are side picking. We become the truth seekers. And to seek truth along the way, you're going to have these dragons to battle, and you have to hunt these liars down. And really, at the end of the day, when I say a script and trying to program someone to do justice, that's the influence business. That's the storytelling business. And the best form of influence is telling the truth in a form that another human being can actually like receive and use it. And that's the techne process in its simplest form. Seek the truth, create order, exercise judgment, and engineer persuasion. I've practiced law since 2001, and over the years, I've managed and trained a lot of lawyers. I've specialized in the falsely accused, so I've represented people that have been, humiliated and shamed and have been going through the worst experience of their lives. And I've helped other lawyers, and I've learned from other lawyers, and I've worked business deals. I've taken a company public in Canada, and I'm preparing serious cases right now. And so when I say that I've seen some things, I mean I've seen and heard some things, like maybe know where the bodies are literally buried. So throughout these lectures, we're not scripting testimony. We're building a script, a program that the fact finder will write over into their own minds so they can interpret the evidence in a way that finds the truth and gives you justice. So I put this little testimonial up here because people call lawyers when they're scared and they're feeling helpless. The work's not just memorizing statutes and becoming like the Google or Chat GPT of the case or the law. It's our craft, our technique. So aggressive advocacy is not yelling. It's not just like pounding the table. It's this disciplined preparation and helping clients in a way that makes them feel safe, makes them feel protected, and makes them understand the process and trust in you that you're doing the right thing. I think the best way to have someone trust that you're doing the right thing is tell them how you do things. And that way they can evaluate for themselves if that process is something that they're willing to trust, even though they may really like you and they want to trust you. In our webinars in the past, we've got a lot of feedback, and the feedback is usually, wow, that's a lot of information, right? And I need to watch it again. So the reason that we recorded this as an Evergreen live session is because I've had people come back week after week, and I was doing the same material over and over again, and half the people would want to see it again, want to hear and want to ask more questions. Other people wanted to go on to something else. So here we are with a system now and a group of people that are joining us week in and week out live in our Saturday community. And I really appreciate their feedback. And I want your feedback. I want you to make comments on what you want to hear. And if I haven't covered it here, we'll try to make the next lesson address your questions, or we can bring it up on Saturday in the clinic. But we're giving up some time here. And honestly, I started this clinic and helping folks on Saturdays because I was finding myself up early in the mornings doom scrolling or staring at my phone while the kids and my wife were still asleep. And I finally thought to myself, like, what am I doing here? Rather teach people how the system works and not waste my time in an undisciplined fashion. Now I got to force myself on Saturdays since I don't lift weights or run very well in the mornings. Figured at least I could do this. Because I used to do a lot of free consults. I still do through the clinic, and my intake director will interrupt me and be like, "Hey, this person's got a really great story. It needs your help. Maybe you could just talk to them for 15 minutes." And sure, we do that all the time, but oftentimes these aren't very productive. It's not really the best place for like figuring things out in like 1 hour. People get confused, and our job is to kind of center them, right? And I think if you go through this process, you're going to be more productive when you try to do these consults with people, because if you're talking to an attorney after going through this, you should be a better communicator, I think. But a free consult in general will become like 30 minutes of trying to figure out what they mean. It's like, it's a cool exercise for attorneys because people are just vomiting out information and we're trying to figure out what they want. I also put a slide here to show you that, and we don't have, not everybody's a big fan. This person here gives us a 1 star because we didn't answer the phone. We get hundreds of calls each month. And part of the reason we started this clinic is because there's things we tell people all the time that would help them be either a better communicator to their attorney or better prepared to be a pro se litigant in trial. And that's the mission here today. But before we go much into the law, I want to explain to you what the St. Maximilian Kolbe Clinic is. It's not just a webinar. I look at it as like an open source law school. The subject matter is procedural literacy, how courts work, how facts become usable evidence, and ultimately, how do you win a case using AI without trusting it blindly? How do you exercise judgment in those matters? So that's the clinic is not a law firm, right? We're a public benefit educational institution. You can follow us on Facebook. You can sign up for the webinar, the live session, and we're seeing people every day in court, and we're seeing them that they were never taught how to do things. So just because you don't know procedural literacy doesn't mean you're stupid. This is very, very confusing. For most of human history, the law looked like Gnostic wisdom, right? And now you're able to learn the law much, much cheaper. That's one of the goals here. We've named the clinic after somebody that I consider very important, a role model. That's what the saints are. We have Saint Maximilian Kolbe was a Polish Franciscan Catholic priest. He was imprisoned at a Nazi death camp, and at the end of July of 1941, after a prisoner escaped, 10 men were selected to die by starvation. One of those men cried out about his wife and children, and Father Kolbe stepped forward and asked to take his place, and the Nazis accepted. And Kolbe and the other condemned men were taken into a starvation bunker. And the part of that story that matters most to me is not only that he offered his life for another man, but it's what he did after the door closed. Witnesses remembered prayers and hymns coming from the bunker. And Father Kolbe, he encouraged the other men. He stayed with them. He counseled them to the bitter end. And after nearly 2 weeks without food or water, St. Kolbe was still alive. The historical accounts differ about how many other prisoners remained and some other things. But what was established that there was a man who some witnesses reported that they saw a literal glow coming from the bunker. We can't verify that as historical fact at this point, but there is eyewitness testimony. I encourage you to go do some research. The thing I find most important about how St. Kolbe relates to being a lawyer is he acted as a shield for another man when it mattered the most. He acted as a counselor to men when they were dying and suffering. And people come to lawyers in their darkest periods of their lives. They're afraid. They're isolated. They feel like the government or the opposing party, or their ex, the judge, their family, everyone's turned against them. And a lawyer can't always save them. But a lawyer can help provide hope. A good lawyer, a good friend can stand by someone when they're going through the toughest times of their lives and shield them where possible, help them preserve their dignity and counsel them to the very bitter end. The clinic can't stand by everybody in the courtroom, but we can at least try to get some of that knowledge and structure. Because what you're facing here is a lot. And I understand you're going through the two battles of the case. You're going through what you're trying to do to win, like the battle to win the case. And then you've got the battle how to survive your case. And every cases can be different. So I think the next question is, what sort of case are you facing? And I would ask you to put into the comments, because this is very helpful data, because we're gonna use this to create other items. I also want to know where you're from. A lot of you guys that come on the Saturday are from not from Oregon, and we appreciate that. And we try our best to keep things sort of jurisdictionally agnostic. I think generally, justice and fairness, should be agnostic on your location. But I'd also like to know, if you're in Oregon, what county you're in, what state you're in. If you're outside of Oregon, what type of case. Do you have a hearing coming up? Have you filed anything yet? Put that into the comments. Are you the petitioner, respondent? Are you here on behalf of a friend? And also, how far away is your deadline? Because that's important data too, because there's certain things you really need to know if you only got 7 days, but there's discovery tactics and requests for production and depositions you can do pro se or with a lawyer if you have some time. Maybe you need to file a motion to postpone. Maybe that's something we need to cover in a future one. But put your questions in there. Don't try to tell your whole life story, because comments are public, and your enemy may be reading this. Use a pseudonym if you need to, or pause the video and make some notes, and feel free to contact us at the clinic under the same rules, and do that confidentially over our Saturday live sessions. I think the next step would be to talk about what I consider the bookends of the case. But before we do that, before we move on to that, I would ask you to subscribe and comment anonymously, keep it general. The more people that participate in this ecosystem, the more we can get the word out. So folks don't have to go fight lawyers by themselves without knowing things. That's not fair, right? It's just not fair to be going to court alone. Why can't we have court-appointed lawyers for restraining orders or stalking orders or custody cases? Well, because the ruling class has decided that they would rather spend resources elsewhere. And until then, until we actually have a government represented for and by the people working in their interest, you're going to have to struggle through this alone, and hopefully this helps. So, please subscribe. All right, the next thing I want to talk about is the substantive law of the case. This is what I call the bookends of the case. And what I mean is every case starts with a document, typically, right? It might be a petition, a complaint. You may be like an arrest phase and you haven't received any documents yet. You're being investigated, or maybe there's some conflict in your marriage and you're worried about what's next. But what you can rest assured, to get a case going, you need to have a complaint, a prayer, a demand, some sort of motion. And that's the operative document that tells somebody what they're asking for from the court. And at the back end, the other bookend of the case, it's what the judge is going to be required to decide and what prism they're going to be looking at it through. So if in a criminal case, you'd have the indictment, the elements of the case. The end of the case, you'd have jury instructions. In a civil bench trial, you may have a trial memorandum that serves as a bridge throughout the case. But in between is everything that goes into a case: the story, the competing narrative, the investigation, the discovery process of how you learn about what the other side has, what witnesses you have, the documents, everything, the rules of evidence and how they weave through the whole case, what objections, and finally, the decision, the judgment. How do they decide a case and what is actually being decided? So you need to know what the legal elements are. Legal elements are the required propositions, like a checklist, like things in order to prove your case, you have to prove every one of these individual things. It's something you have to say out loud, some sort of magic spell to make this outcome happen. And if these things don't get connected, you lose. So if the law requires A, B, and C, and you only prove A and B, but prove it awesome, prove it really well, great witnesses, you just did amazing, it's dramatic, it was emotional, but you don't prove C, you lose. And there's some statutes that have alternative ways to satisfy an element. And some cases could involve like conflicting elements and defenses and claims. But that's why you need to read the actual law instead of relying on someone's internet summary. So next is like, what's the burden of proof? Those are two related ideas. Like, what do you have to prove, and how much do you have to prove it, and who has to do the proving? Who has to come forward with enough evidence to put the issue before the court, and who ultimately has to persuade the jury or the judge? Very, very different questions, and very important. You've got to know what the facts are, and you've got to know what the threshold is. So it's normally going to be 50% plus one. That's the burden of proof. So if you think of like the scales of justice tipping just slightly in your favor, that's the preponderance of the evidence. Proof beyond a reasonable doubt would be a criminal case. That's proof that's if you doubt it and it's based upon reason, then you have reasonable doubt. Reasonable doubt can be lack of evidence, conflicting evidence, or affirmative evidence. Imagine yourself pushing this rock up a hill. And a very wise lawyer, Lissa Casey, always talks to juries, and when she's talking, he tells them about the burden of proof. You're rolling this rock up the hill, like that sad Greek story. And the person with the burden of proof is doing the pushing. And if they get it to the top of that hill, then they won. But if it starts rolling this way, 50% plus one goes to less than 50% and it rolls back down. In a criminal case, imagine you have to deadlift that rock up to clear and convincing evidence and all the way up to proof beyond a reasonable doubt, that extra push. And so at the end, that means the fact finder believes the proposition that you're attempting to prove. And don't assume anything in a case. You're going to have to line it all out, and that's what we're going to try to talk about, because we don't want you to look unprepared, like you're wasting time. You want credibility when you're in front of a judge. You want to look like you know what you're doing, look like you're in control of yourself, because you're being judged in everything you do. So eventually, there's this decision matrix that has to filter everything through. In a bench trial, it won't be like jury instructions, but there's going to be the statutes, the elements. So I'd ask you, work backwards from the decision. Don't begin with, how do I prove they're a liar? That's very important, very important. But begin with, what is the court being asked to decide, and how is the court legally supposed to decide it? So that's a very basic question, but very complicated, that will require you to know what the law is. But once you know that, then you can figure out which facts matter and which evidence proves those facts, which witnesses to call. We'll get into that and try to answer some questions. But first, I want to use some common examples. Most cases when people are going to court are going to be criminal cases. They're going to be restraining order cases. They're going to be stalking order cases. And I want to talk a little bit about the most common areas. But before we do that, you can register for the Saturday live session at stkolbe.org. We'd ask you to follow and subscribe, and there's some QR codes if that helps. If you're watching this on YouTube, on TV at home, you can snap it with your camera as well. But let's talk about what's restraining orders. What are they? They're weapons and they're shields. Right? People file false restraining orders and stalking orders all the time to gain advantage in custody cases, or because they are socially awkward and don't know how to tell someone to leave them alone. And there's a lot of people that need restraining orders and stalking orders because they're in jeopardy without them. And all those get litigated every day. So no matter what state you're in, there's going to be some sort of equivalent statute. But I'm going to use Oregon as an example, and it's a good example because it's very common in other states. Now, California, Washington may have like coercive control laws. Maybe we'll, if you're facing one of those, maybe we'll do another session. So put down there if you've got questions about coercive control, about how to win it or lose it, win those cases, or not lose any of them. But if you're being accused of coercive control, or if you are the person that is the victim of that, or if you're the person that's abusing the system to gain advantage in the custody case, F off. I hope you lose. And I hope your opponent, your adversary who you're lying about, comes here to learn something. And I pray to God that the court has wisdom, that the judge has wisdom, and justice gets administered properly. So in Oregon, the current law is that you have to have a qualifying family or household relation. It has to be abuse within 180 days, 6 months. We have to have somebody doing abuse in that time period. And abuse could be what we think of as bodily injury, or controlling someone physically. It could be intentionally, knowingly, or recklessly actually causing that injury, or it could be putting someone in fear of imminent bodily injury, like putting your fists up and pretending to punch them or something, or it could be attempting to do that, like a swing and a miss. So these things are very fact specific, but you have to know what actually needs to be proved. So I'm not going to try to turn any of you guys into like a Family Abuse Prevention Act lawyer today, but these are things you have to know how to prove. We can go into more detail about that. Put any questions in here. If you're going through restraining order, we can do a longer form session on that as well. But I would say when you're thinking about this case, any case of violence, if you're the petitioner or the state or a plaintiff or in a custody case, your job is not to tell the judge that we had an altercation. That's a conclusion. That's vague, right? It's a class of something that could happen underneath. It could be words. Like, I want to know the story. I want to be like I'm on a jury and I'm a blind man, and I need to see in my head the video of the incident that you're describing, but not just what's happening and the hand movements and what people are saying, but what are they thinking too, and why are they thinking that? And that's the story in cases involving an incident. That's what you need to be able to communicate. Like, what body part touched what, in what order? What were the exact words or best recollection of the words that were said? What happened immediately before? What's the backstory? Why were they mad? Why were they arguing? Was there an injury? Is there any proof? Is there any motives to fabricate that we can prove? Is there video evidence? There's a lot to think about, and these apply to all cases. But we had an altercation is not a fact pattern. Give me the video frame by frame. And we can do that same checklist in Oregon for stalking orders as well. And these will be generally true in other jurisdictions too. The stalking order is one of my favorite areas of law because I guess it sounds a little sick, but I like litigating them because the elements are very simple. The facts matter intensely, and the free speech implications are fascinating in Oregon in particular. We have a free speech statute or free speech constitutional provision, Article 1, Section 8 of the Oregon Constitution, that's greater and more powerful than the First Amendment. So at a high level, stalking will mean repeated and unwanted contact. Unwanted meaning you'd really a darn good reason to know that you shouldn't have been contacting, not because somebody ghosted you and they're too cowardly to tell you to leave them alone. See that a lot. And it's got to be an alarming contact. It can't just be made me uncomfortable or hurt my feelings. Like, words aren't violence, no matter what they've been trying to teach you in Woke One. That's not true. Words can be illegal if they create, in Oregon, a fear of imminent serious bodily injury. Imminent meaning like something's about to happen. It's got to be more than a mere impotent expression of frustration. It's got to be more than, oh, I ought to kill you, right? But I mean, I ought to kill you, me coming at you with my fists up, it's words plus actions. In other states, your results are going to vary because, a lot of states suppress free speech. But regardless, putting someone in fear of bodily injury is actionable as it should be. So unwanted contacts, violence is going to be assumed unwanted. So get to know the elements. The other real common area that we see is family law cases, the best interest test. Restraining order is not a custody case, but they could have a family law element to it. The facts may overlap. Abuse is going to be very important in a family law case. Typically, there's like Oregon, for instance, has as a factor abuse of one party against the other, along with who's the primary parent, who's most capable of facilitating an ongoing relationship with the other parent. There's a lot of factors here, and for the best interest test. And legal custody is about who has the decision-making authority for the child, right? So if you got a custody matter, put it down there in the comments, and we'll see if we can come up with some answers to your questions down the road. But now let's go into my favorite thing, the rules of evidence. Rules of evidence it's the minefield that we do these legal battles in. And relevance is the entry ticket to the battlefield, by the way. Evidence is relevant if it has any tendency to make a fact of consequence more or less probable. The question most people miss is, what is a fact of consequence? Definitely an element, right? Definitely a defense, definitely a state of mind that caused someone to do something, and that something that was done is a fact of consequence. Is it a credibility issue? Do they have a motive to fabricate? You have to be able to articulate these things. So when you hear the lawyer on the other side say objection, irrelevant, or objection, relevance, you've been prepared for this moment. This is a defining moment of the case. When you hear objection, irrelevant, you should be very pleased, because now you get to do a little mini closing. Well, Your Honor, this shows the state of mind that this person was in when they acted this way, which gave them a motive to fabricate because they were very angry over the past wrongdoings and the feelings of being slighted. So that caused them to come into court and lie today. Oh, okay. Overruled. But be ready with the story, right? This is the influence game. Be prepared to sell the case at the right moment. Figure out what you need to prove and tie it to a legal element, and you'll have great opportunities to keep your evidence in. But beware things like he's a bad person, she's crazy. Those are probably relevant, right? Because bad people tend to continue to act in bad ways. But that wouldn't be fair to have a legal system where you could just say that, because we care about facts. We don't want people to come up with improper character evidence, which is the next rule. That's Rule 404 in all jurisdictions. So things like he's a bad person, she's crazy, he's a narcissist, she always lies. Those are labels and conclusions, and those are therefore character evidence, because when you introduce evidence like that, evidence that makes someone look bad, you want to do that, but you have to do it in an admissible way. So the general rule doesn't let you prove character, or doesn't let you prove someone acted a certain way merely because you say that's their character. So you can replace labels with conduct, and you can use prior bad acts. And they're sometimes relevant for another legitimate purpose, such as like motive, someone's intent, like why did they act that way? What were they intending, and if you could show a prior bad act, to show identity, for instance. The classic example is like a modus operandi. That you have a defendant who likes to, he's a serial killer and likes to cut off the ears of his victims, and then you find an earless victim. That sounds like identity, or maybe a copycat. So you're going to have to argue that. Then you'll have to argue whether or not that's unfairly prejudicial, and all these things that are very fun for lawyers to deal with, but you'll have to understand that they also have to be dealt with when you're pro se. And so I've got a book that I wrote called Finishing Machine. And the question at the center of it is, was it road rage murder or was it self-defense? So my client was a Marine sniper and a former UFC fighter, and he was accused of murdering an unarmed man. And it was this road rage confrontation at night. You can get it for free on Kindle Unlimited. And I find it as like a good case study, as an early laboratory for almost everything I do today, like false narratives, liars, character evidence, prior bad acts, credibility, and I think most importantly, courtroom politics, and how that gets woven together with media pressure and a gag order and tyranny in the courtroom and abuse of power. And what happens when the public story and the courtroom story collide? And the point is this: we weren't only trying to influence what happened inside the courtroom itself. We had to understand that what was happening in the court of public opinion while the court was trying to muzzle me was important, because my client was living through all of that at once. And the way you fight bad speech and lies is not by muzzling people, by more speech. That's an American concept that we have the Second Amendment to protect. We don't need to necessarily try a case in the court of public opinion, but what we need is fair judges. And if you want to learn a little bit about courtroom politics, or about unfair courtrooms or improper character evidence, there's some chapters in there that may be helpful. So it's called Finishing Machine. It's available on Amazon, Kindle Unlimited. You can get it anytime. So the next area I want to talk about is reputation and opinion evidence for truthfulness. So evidence code has specific rules for opinion and reputation evidence only regarding the character trait of truthfulness or untruthfulness. This is like an exception to the character evidence rule. So this can matter in a genuine credibility contest. So you don't want to assume that you can parade in every prior lie in the courtroom, because those are prior bad acts. Those are not reputation and opinion evidence. So the law doesn't necessarily give you an open ability to bring in countless witnesses, because eventually someone will object that it's cumulative. But what I would suggest you do is build a credibility plan and look for prior inconsistent statements, right? Because my grandma used to always say it's easier to remember what happened than remember what you told everybody else. Look for motives to fabricate. You know, if this is a lie, then why are they doing it? You just that unlucky that somebody just made something out, they never met you, made something up, never met you before? Or were you kind of a prick to them? You know, nobody's innocent. There's only one innocent man. And there was a pretty cool trial about it that became very famous. He was falsely accused, but he was innocent. Most people that are falsely accused are not innocent. And I mean that sort of like in the moral sense, that they were a prick to somebody, they were unjust to somebody, and then that person responded with revenge and a horrible evil. But you got to find out why they're making this up. Tell me a logical story why they're making it up. And if you have that, and you have inconsistent statements or any combination thereof, and you can also bring in a witness to say, yeah, I've known this person for a long time, and my opinion is that they are a liar. They have a difficult relationship with the truth. And that might be enough to push it over. Confer with a lawyer and see if that's a good idea. The next topic is very important for particularly pro se litigants. Hearsay is an out-of-court statement offered to prove the truth of the matter asserted. We spent like a half a semester in law school about this. Well, think about it. Why does the rule exist? Fairness. All the rules are because you are owed justice. Justice is defined as giving someone what they are due. You are due a fair process, a due process. And how would we let like a piece of paper decide someone's life if nobody can cross-examine the person who supplied the words? That's why you can't let like witness statements come in. And I hear that a lot. I see it a lot at court. Someone who says, well, my neighbor was there and they can't make it to court today, so they wrote this statement out. Alarm bells, objection, hearsay. It's not coming in. It's not coming in. Use your subpoena power to subpoena the witness. File a motion to postpone. Tell them why you didn't have time to do that. Look for an attorney. Tell them you're in the process of finding an attorney. And, I'm from Kansas City, Missouri. I'm from the Show Me State. I really like the hearsay rules because don't tell me what somebody said, show me, like bring in the witness, the admission, the exhibit. And the exhibit can't be a statement that you cannot cross-examine. Like I can't be like, are you biased? No, they're not here. That's not fair. Very important rule. People mess it up all the time, but there are exceptions to this rule, and there are things that aren't hearsay. So your opponent, things they say outside of court is a statement by a party opponent and is not hearsay. So what they said in text messages, what they said on a video and a recording, assuming it was lawfully done, you can use that to prove a point of consequence that, that is in fact relevant. Police report is not a magic truth certificate. Sorry, you got to call the officer. And by calling the officer saying that somebody told him something, that is still hearsay. You got to bring in the eyewitnesses, and with some exceptions, impeachment, business records exception. These are great things to hire a lawyer about or to ask AI about, and we can teach you a little bit about that later. All right, so next we're going to talk about exhibits. But before we get into exhibits, I want to take a moment to help the clinic reach the next person. So you can comment below. You can follow the clinic page on Facebook, St. Kolbe Justice Clinic. There's links in the description. You can join a private community. You can leave an honest Google review. You can Google Mike Arnold, Eugene Lawyer, if this has helped you. And of course, you can share and comment. I mean, this is free public education, and participation is what expands it. It's what helps the algorithm notice it. And it allows this secret Gnostic wisdom to be given to the people. This is your law. A government exists because of the will of its people. They work for us. And lawyers don't get to keep all that information secret anymore, nor do we want to. We don't want to be spending our time looking up laws and teaching people how to teaching people what a certain law means. That's important, but information is getting close to free nowadays. And I think it's important for us to get the word out so you guys can have a community where you help each other fight the powers that be. So let's talk about exhibits. So there's going to be like local rules in whatever jurisdiction you're in, and probably state rules on how exhibits are allowed. Go to the website, Google local court rules for your county. In Oregon, check the Uniform Trial Court rules. They're going to tell you how to prepare exhibits in advance. Generally, you're going to have to bring copies for the court, opposing counsel. You're going to mark those exhibits clearly. You're going to do it in advance so you don't waste everybody's time. And you're not going to hand up a bunch of loose, unorganized documents, because judges, they expect, or at least hope for, efficiency. They probably expect disorganization, but that hurts credibility. You're being judged. If you're bringing up a bunch of evidence to make your ex look bad that's not connected to the case, then you're going to look bad. If you're not prepared, that's just another strike when someone's trying to evaluate you as a credible person. So most jurisdictions require an exhibit list before the hearing. The exhibit list is something that says the exhibit number. You usually give a copy of that to the court, has a description, has whether or not it was offered, accepted, or rejected, and they can check a box. And there's usually forms available online. And this is just good for you personally, even if you don't have even though you don't have that requirement, you're going to want to, on your own, in your trial outline, have the exhibit number, have the description, have the fact that it proves. Why is it relevant? And what witness are you going to use to make that admissible? What's the foundation, which we'll get to in a moment? How do we know to trust that thing to be what we purport it to be? How do we authenticate it? And then you need to know what the likely objection is, and you need to have researched what your plan is to respond to an objection. And you just don't assume that a document proves what it says merely because it exists and it's brought up in court. Not everything is self-authenticating, right? And you'll look this up on AI, authentication. You're gonna have to plan for this. There's a lot of work to prepare for a trial. Lies are chaos, and the truth is organized. The truth is beautiful, and there's beauty in organization. So if this is helpful for you, I'd ask you click on the QR code or Google Mike Arnold, Gene Lawyer, or go to Facebook, write a review. Just get the word out there so the algo doesn't make us pay for people to come learn stuff for free. This is a community, and let's build it. Let's talk about foundation. But the practical questions are: what is it? Who recognizes it? Why or how do they recognize it? Is it accurate? If it's a physical object, is there a chain of custody to know that this is what we say it is? Or is there something uniquely identifiable, like a signatures on it, or there's perhaps a serial number on the gun? And then you need to look how it gets connected to the case. Of course, has it been modified or changed in any way as well? This applies to everything: texts, emails, photos, and records. And AI is really good at helping you come up with the framework for authentication and foundation. So no foundation, no admission. No ticket, no laundry. And the real job is just to identify every evidentiary link before you get to court. Okay, this is a lot to prepare for. So make sure you have foundation. Don't get left with, like I had this jury trial once, homicide trial with Lissa Casey, and the star witness for the state had this animation they wanted to show regarding, how it was a vehicular homicide case. Wanted to show how that happened. They put on a bunch of evidence, asked a bunch of questions, and went to offer the exhibit to show it to everybody. And I said, objection, lack of foundation, sustained. That was a shocker. The other side continued. They asked the question again. Objection, lack of foundation, sustained. This went on for like 30 minutes. And the judge let it go on. And eventually they called other people from their office down, took a recess. They worked, and eventually they got it in. And I got to say that prosecutor was a bad mother effer, because he did not give up. He had perseverance, and he figured it out, man. And you don't want to be in that position, because a lot of judges won't be that patient when you're having to figure out, how something gets in and say the magic Gnostic words. So figure out foundation, or you could lose. And that's just in essence being respectful, not wasting the court's time, right? Because we don't want to waste people's time. Want to be in there and get in and get out. Don't mess around. So the next thing I want to talk about is the case narrative. Just generally speaking, what are we using to communicate? Right? It's a story. It's something that you've got. You can whiteboard this. You got your sticky notes, whatever. You got your good facts. You got your bad facts. Write them down. Put them all out there, and then figure out what you need to prove to either show that the bad facts are untrue, or how do you say a logical reason that people are claiming that they are in fact true? Is there a motive to fabricate? Did they fail to collect the evidence properly? Is it something sort of some fraud? But you've got to have everything explained, because the human mind doesn't like the edge cases that just keep you like asking, oh, well, what about that? It's just a detail that keeps popping in my head. I need it explained. So when your case starts, you're going to have an opening, and that's like a roadmap. It's not argument. It's not about trying your case or testifying. I see a lot of pro se people get some flack, from the judge when they're trying to do openings, trying to do it like Perry Mason, or they're trying to testify, and the judges get impatient. And don't sweat that if that happens. Just say, thank you, Your Honor, and sit down. But try to make it very succinct if they're like shorter trials, if you're pro se. But essentially, you want to tell a story. So when they hear the information, it makes sense already. It all gets fit into this logical framework. It's the most important thing of a case, is the story and the logic. And of course, the facts and the evidence, everything links into that. But that's the map you're creating. So what happened? What will the facts show? And why does this make sense? So you get that. Say it from the first person perspective. Tell your story. You've done it before. You've told it probably lots of people. Well, just figure out how to make it admissible, not objectionable. And you can use AI to do that. Don't exaggerate, be respectful, and don't waste the court's time. So the next part of a trial is the opening, case narrative. And we're talking trial here, right? We haven't talked about discovery. There's many a slip, twixt a cup in the lip along the way to get to trial. A lot of mistakes can happen, a lot of things you can do to increase your odds. But once you get into trial itself, you have the opening, and then whoever has the burden of proof has the first witness. That's called a direct examination. In that direct examination, they're going to be asked to tell a story without leading questions. So if you're doing direct, make sure you don't tell them the answer. You don't say, isn't it true that you saw an assault? Objection. Leading. And be very careful, because you could lose that witness. A good judge will punish someone fairly for giving suggestive answers when it appears that they're trying to get that person to say something that wasn't true. Like it's just awful. You see it all the time in interviews by police. You see it in life all the time. When you're trying to get someone to say something, you tell them what the answer is. So the questions are better like what happened, get their background, get their connection to the case, You want to know who this character is. This is a live action play, no rehearsals, one day only. And so you want to build the credibility of your storytellers, of your communicators. Everybody's an influencer in the case. So build that foundation around them. And then the second part is you'll have a cross-examination. So after you're done with your questions, you'll say no further questions. The judge will say, cross. And those are going to be like usually short, controlled questions. You want to be careful not to be asking long, open-ended questions and saying what happened next, what happened next, what happened next. Because if you did proper discovery, you're going to know what you want them to say, and you can actually test credibility that way. Like, death by 1,000 cuts, short, walk them through the case. And if you do like a little bit at a time, they'll start saying yes, yes, yes. And then when you hit them with that thing that they screwed up on, they're more likely to tell you the truth. So test credibility, point out inconsistent statements, and work on those motives to fabricate, expose those inconsistencies. And don't argue though. Don't do long questions where you're sounding argumentative. Don't lose control. And if you're being cross-examined as a witness, man, God bless you. That's a tough situation, man. If you've been in an argument at home, you've been able to like walk away. You could change the subject, you could deflect, and certain people will gaslight. Try that in court, try gaslighting about some sort of fake emotional distress that you've had from my client, and then I'll give you something to be distressed about. The cross-examination is the single best engine for truth ever created. It's better than waterboarding. And if a lawyer or a litigant does it right, they claim that they're having psychological distress about their made-up BS. Wait till they go home tonight. They're going to have nightmares about cross-examination. It is brutal to be exposed as a liar in front of people. And that's why settlement is actually possible with liars. You just have to show them the risk and give them a golden bridge which to retreat upon, some sort of settlement that allows them to save face. Because if they knew what cross-examination had in store for them, they would not want to pursue this campaign, because cross-examine exposes liars, and it's a lot of fun. You can look online and you can see examples of really great lawyers doing cross-examination, and it's something to learn there. But be very, very short, and it's not like on TV, right? You don't get to turn to the judge and start telling a story in the middle of cross. So next, I want to hit a couple objections that are going to be common. Objection relevance, objection hearsay. What did he tell you? What did she say? Those are magic words that a judge may help you with if they're the type of judge that helps pro se people. Pro se meaning self-represented. But those are triggers. When you hear that, object, hearsay. Some things are going to be irrelevant. Oh, he cheated years ago. I mean, it may be relevant. Maybe that's the motive to fabricate. But judges don't like, particularly custody cases, they don't like to be hearing people throw mud at each other. They just care about the kids and what's best for them. And then calls for speculation. Like, what did he think? What did she want? Those are inadmissible. Of course, you've got improper character evidence, which we talked about. Objection leading on direct. Objection asked and answered. Compound question, beyond the scope of direct examination. Someone starts asking questions that has nothing logically to do with your direct and cross. And don't treat an objection like a personal attack. Don't lose your temper. And when you hear like lack of foundation, ask yourself, what does the court still not know about this item or witness that would help them believe that this thing is real? And when you hear hearsay, identify the speaker and the purpose and whatever exclusion or exception that you prepared for because you listened to this and did the research as I recommended. And now we're going to talk about discovery briefly. This could be a week-long seminar on all the ways to leverage the tools that are available. Discovery is the process that allows you to know what you need to know about the case. It's an intelligence operation. Presenting evidence is only half the job. The other half is finding it before court. And the possible tools include requests for production, subpoenas, subpoena duces tecums, which are subpoenas for records, You can do depositions where you ask people questions before court, interrogatories in many jurisdictions. You can have an investigator just go around and ask people questions, right? You don't necessarily need to have them under oath. You could have expert witnesses during the discovery process, review things, and there's different rules depending on jurisdictions. You could use like public records requests. And if you don't get what you're entitled to, you need to know how to file a motion to compel or hire an attorney just for that job. But which tools are available depends on the case type, the jurisdiction, the timing, what the court orders say. And when you want someone to appear to testify at trial or deposition, you've got the power of the subpoena. You've got the power to impose your will on someone. Use it. Don't bring the piece of paper in that can't testify, subpoena the witness. And a records subpoena can command the production of the documents that you need to prove your case in advance. There's a lot to unpack here. So if you've got specific questions about that, put it down in the comments because, I could talk about anything and I just want you to have what's in my head. I want you to have this session, this first day of open source law school. I want you to be able to issue spot and then be able to put questions down in the comments about what you want to cover next. And maybe someone else can comment, hey, there's another video out there that'll answer that question or tell you how to prompt AI. But if you don't have the evidence, what's the point of going to court? Do the work. Don't be surprised. Prior proper planning. And we'll do a longer class about discovery at some point. But if you want an example of a subpoena, you can Google Oregon court subpoena PDF or your court and maybe your county, or you can use this QR code here. And of course, you can always save this video and go back to it. Just make sure you have a little understanding of everything. So when it comes up in your case, you're better able to adapt, right? No battle plan survives first contact with the enemy, but battle planning is invaluable. Battle plans are pretty useless because the minute you get in the battle, it's, I don't, but scripts are the battle plan. And then you'll have to be able to pivot, but you can pivot from here to here rather than write it all, in the middle of trial while you got the cortisol and adrenaline going through them. So now I want to talk about what you can do without a lawyer. Artificial intelligence is a force multiplier. It really is. It's used by sophisticated lawyers every day. It's used by bad lawyers often too, where they get hallucinated cases. And you see most of the literature online and is going to be about all the fools that used it for research and drafting purposes. But there's a lot of professionals out there using it to help temper an email. My ex did this, and this. He's a total a-hole. I need to write him an email telling him why he's so horrible. And your AI is going to be programmed if you set up a project correctly to try to remember that everything's an exhibit at trial, right? It's going to turn that diatribe that made you feel good into, dear Mr. X, please be advised that I don't find it appropriate for you to call me names in front of our child. If you continue to do so, I will have to take legal action by filing a contempt of court against you or move to modify parenting time. Please talk about me to me, not in front of our child, or whatever AI spits out that's better than your angry email. You can also use it to do some background research. I mean, there's things that used to take me 4 hours to do that I can do in 5 minutes and be like, aha, oh, I remember that. And then I can click on things and get in a deeper dive. But it's a huge tool for the non-Luddites out there. There's a lot of lawyers that are still they'll promise the clients that they'll never use AI. And I'm always thinking to myself, okay, you remember that name of that tribe that said, F the bow and arrow. We're going to stick with our rocks and spears. And the name of that tribe? No idea. They're extinct. Nobody cares. It's forgotten, right? Don't be the one that's the last to use the most modern weapon. But don't be the first to adopt the broken one either. You don't want a cannon blowing up in your face. And AI is very dangerous. But it's helpful. You can build chronologies. You can separate facts and allegations from assumptions and unknowns. You can ask it to help you create an allegation matrix. You can use it to map good facts, bad facts, and then map in the exhibits. You can build an exhibit, like a timeline exhibit or a witness index. You can ask it to red team or pressure test your case, and then to pressure test it from the other side. You can have it argue with itself. And then by reading those conversations, you can learn, and then you can exercise judgment, because the AI does not have judgment. It doesn't have a soul. It's not biological intelligence. It's a large language model. It's really good at predicting what should be said in a certain situation, which makes it great for trial preparation. But you still need to use your own judgment or hire a lawyer to give you judgment or run it by a friend or something. So don't ask like one random legal question and then treat that as the law, right? Use that as the first stage to your constant plan to learn more and more and more. You can use different AI platforms to build case projects. You can give it instructions. You can give it sources. You can pull all the laws in every case that you found important. You can dump it into the sources, but never assume that an ordinary AI conversation is privileged and confidential. There's competing cases out there in federal court. There's a lot of talk about this right now. I know right now I've got subpoenas out asking for copies of people's phones so we can see their text messages, their Google histories, and their Chat GPT histories. There's certain circumstances that may be privileged. And in many jurisdictions, the work product privilege doesn't just apply to the lawyers. It applies to anyone that's doing something in anticipation of litigation. But this is not settled law. It's dangerous. But I've been whooped up by pro se litigants using AI. Even when they're misciting the cases, they're misciting the statutes, they're kind of close, and they're at least able to use that to argue their facts within that paradigm. And they've done a hell of a job. So I would say don't ask ChatGPT like one random legal question. Build a machine. Use a tool for the job. You don't shave with a chainsaw, right? You gotta be more delicate. Just be very careful. AI doesn't just get things wrong. It can make you confident, like that you are right. And we see it all the time as lawyers. People are so sure that the AI told them the truth, and it just didn't. It's lying to you to keep your attention, because your attention is valuable to them. So pressure test it, steel man the other side, and we'll do other seminars on AI in the future. I've done a presentation at the Saturday live show. You can go to stkolbe.org and sign up for that. We've done that, and we've had like a lecture on how you create an Obsidian vault, or Obsidian vault knockoff that makes it look like that has an index, so it more quickly accesses things. And hopefully, by the time you're watching this is all old news, and everybody's using it every moment in their life. And we're still not ruled by the AI overlords, and Sam Altman isn't our king. So good luck in that process. There's a lot available, because you don't have to pay for a lawyer to tell you things like you used to. And at least when you go speak to the lawyer, you can know more. All right. So like what's the next steps you can take? Well, this class is the general framework. People need individualized help in applying it a lot of times. Some people can't afford it. Some people don't want to pay for a consult. They're looking for free consults. But you can better be able to get a free consult if you're able to pitch your case succinctly. That way you don't sound like someone unhinged with sending someone a 20-page Chat GPT word vomit document. Like those are like warning signs. So you don't necessarily need full representation to get the value from a lawyer. Perhaps your budget is very small. You're calling around saying you only got a couple $1,000s to spend, and everybody's quoting you $5,000 to $30,000. Do you give up? Or do you hire a lawyer for like a focused strategy session, maybe to help you identify the legal questions that you give to them in advance that they evaluate, and organize the evidence in advance, so you're able to communicate with a lawyer? And maybe they just help prep you as a witness. Maybe they cross-examine you. Those are very valuable. You can definitely come to our Saturday live session. We can try to help you out there too, at stkolbe.org. You can even contact our office and schedule an appointment. You go to mikearnold.com. You can talk to our intake coordinator as well, and maybe she can refer you to another lawyer. Or you can put down in the comments below the type of case, your jurisdiction, and what you're looking for. Maybe, even your budget if it's confidential and you've got like a pseudonym or something. And maybe someone will comment and help you out, because this is a community. Like we're children of God. We all deserve the dignity of a fair process and not being surprised in court. Even if we're the ones that were doing the bad thing, we're still deserving of a fair court proceeding before the government can order us what to do, because the alternative is bleak. It's dystopian and it's Second Amendment time, and it'll hopefully never come in my lifetime. But you can see the writing on the tea leaves that that the powers, the oligarchs, they're controlling more and more important parts of our economy. They're controlling the next level of weapons that can even design the next weapons. Who knows what's going to happen with the progression of AI? But right now, it's a useful little tool in your arsenal, and I strongly encourage you guys learn how to use it, because I guarantee you the other side is using it, or you should at least assume so. So if you have the opportunity to do a Google review for us, now would be the time to do it. You can use the QR code here. You can Google Mike Arnold, Eugene Lawyer. This helps get the word out. The Facebook page, you can just Google St. Kolbe Justice Clinic. There's a private page as well. And all these things are super helpful, because we're doing this because we care about you, and we know that you're going through a lot right now. And some of you are alone, and you're fighting these two battles. In the first battle, how to win a case. The second battle, how to survive a case. And if you don't have somebody on your side, like a lawyer, and everybody's turned against you because of these allegations, or you're going through a divorce and you found out that most of your network is your spouse's network. So you're not going to be able to do this alone. You've got to trust in someone. You can trust in God. You can trust in the system, but you have to participate. You can't just blindly go forward without putting in the work. You can't just say, "Oh, I'm going to trust in God and everything's going to be fine." We expect a man to help himself. We expect you to go out there and fight for what's right. We expect you to act according to your purpose. If you're a father, if you're a mother, and you're fighting for custody of your children, if you're a man falsely accused, if you're a victim of domestic violence, your story must be heard in the clearest way possible. And I can never give you a guarantee that you're going to be able to win a case. Nobody can, right? I mean, it's just not possible, and it's unfair to even ask a lawyer to do that. We don't like to tell people. We can give people odds, right? We can help them through that. But there's no guarantees in life. But one guarantee you can have is that you can control yourself, and you can use this time to learn procedural literacy. You can sign up for our live seminar on Saturdays at stkolbe.org. You can follow us on Facebook. You can put down in the comments the questions you want answered, and we'll try to help you in the future. But what I really want to see from each and every one of you is to regain hope, because knowledge is power, and you're not going this alone. We're here for you. There's a community here for you. We want you to succeed. Even if you're on the other side of one of my cases right now, I want you to get justice. All right? Now, I may think you're a liar. I may be wrong. Prove it. Use the tools available to have the truth set you free. Don't give up just because you lost that first round. And by all means, don't give up ever. Because, as they talk about, the great thinkers talk about the theological virtues of faith, hope, and charity. Hope isn't something that you can exercise your muscles and get. It's not like justice or fortitude or temperance. You can practice being a just person, and over time, it becomes habit and it becomes good character. You can practice not giving into your temptations and control your eating and control your desires. But it's hard to practice for hope. And the ancients, they and the early Christian theologians talked about hope as a theological virtue that is not available but for the grace of God. But you have to participate in that. And that's why faith is also a theological virtue. To have hope, you have to have faith. You have to have trust in someone or something bigger than yourself. I mean, you can have faith in the justice system, and that's really having faith in God, because God is all love. God is there to manifest that love in ways that we can understand, such as through justice, through mercy, and we also have to participate with that as well. And one way to do that is with charity, which is the third theological virtue. Charity meaning, loving God above all else and loving your neighbor like you love, as if it's yourself. Love your neighbor. And what is love? Love is willing the best for the other. It's wanting the best for the other. It's not a bunch of chemicals going to our brain. And if we have to love our neighbors, we love ourselves. Doesn't that mean we have to love ourselves too? Don't we have to forgive ourselves for our shameful mistakes? Now you're going through the toughest moment of your life. You've hit rock bottom. Don't give up, please. There's people out there that care about you, that don't know what you're going through. And you need to do this for the future version of you. You have a great opportunity to reframe your narrative while you're going through this horrible experience. What you need to do is look at yourself as it's future you talking to you right now. Future you is going to tell you what you need to do to have a really cool story on the other side, even if you lose. How to act with dignity, how to act with purpose, and knowing that if you lose, your loved ones that are relying upon you, or the ones that you're not going to get to see anymore because you lost, won't because of lack of trying or lack of effort. You're going to put in the work. You're going to focus on what matters. And you're going to trust this beautiful system that is the American justice system. I call it the injustice system a lot because sometimes you have to pay to play, but there are wonderful, amazing judges out there that truly care about right and wrong. And those are the ones that you need to pray for wisdom for, because they have a tough job. They have to figure your life out in a very short period of time. And I think I just want to end this by saying, one thing, and that's, Lord, please guide us in going through these terrible times. Please give us strength. Please give us wisdom, and please give us peace. Because without it, we are living in a world that is chaos, and I don't know what to do next if I can't even think about what's next, because right now is tormenting me. So I just ask everybody to pray for each other, put in the work, and trust in God. Amen.